Please be seated. All right, we're ready to consider our final case of the day, Department of Children and Families versus YM&CM.
Good morning, Your Honors. May it please the Court, Anthony Musto on behalf of the Department of Children and Families. Your Honors, the most overriding concern in termination of parental rights cases is the best interest of the children. And I suggest to you that that best interest is never served by a court rendering a decision without being informed of all of the relevant facts. And if it's a lawyer that doesn't bring those facts to the court's attention, then shame on that lawyer. But if it's a court that refuses to hear and allow the lawyer to do it, well, then shame on the court. And that's what happened here. This is
Mr. Musto, do you think the trial judge acted hastily in concluding the trial? Do you think he was unreasonable in not granting yet additional time?
I think he was unreasonable. Hastily, he acted certainly abruptly. I don't know if I would call it hastily because he said all along, I'm going to do this at this particular point, so I don't know if the word hastily would necessarily apply.
Was the case set for 2 days initially?
It was.
And the judge gave another 2 days?
That is correct. What happened was that it was set initially for 2 days in July of last year.
Yeah. Let me ask you a question. How long do you have for argument today?
I have 20 minutes.
Okay. If you haven't gotten to the point in 20 minutes, do you ask for another 30? And is it a denial if you only get 15?
No, but in this case, you don't have to hear oral argument at all. I don't have a right to oral argument. When the case is brought in the trial court, the parties have a right to present all evidence that is relevant and non-cumulative.
Whose obligation is it to present it within the time allotted?
Well, assuming that...
This is a direct TPR. There was no case plan, there was no finding of dependency initially, right?
That's correct.
So doesn't the department have to prove egregious abuse?
The department has the burden of proving it. The
Okay.
department attempted to prove it. The department was not allowed to prove it because at noon on the second day of the September proceedings, the court said, that's it, you're
It was actually
done.
noon of the fourth day of trial.
It was noon of the fourth day. The first day, the morning was all taken up by motions. So there was actually a half a day of trial on the first day.
Right.
Then there were 2 full days and then half of another day. So it was the equivalent of 3 full days. And on that point, I would point out that the 2 full days, they came back, they had 2 days. On that first full day, the judge took a 2-hour lunch break and broke for the day at 4:50. This is after
4:50?
4:50.
10 minutes to 5?
10 minutes till 5.
What time should he have broken?
Well, I think at the very least it should have allowed the further presentation of evidence. When I was a prosecutor and we had juries, we would go till 7 or 8 o'clock. If you've got a long trial, you've got to get it in. And especially if you're telling DCF, you've got to shoehorn what you've told me is 3 days' worth of testimony into a day and a half. And if you're saying, I'm limiting you to a day and a half to finish your case at this point, at the very least, I think you should give them a full day and a half and not cut them short.
Remind me what the parties agreed to at the pretrial in this case.
I'm sorry, Your Honor.
What did they agree to in the pretrial in this case in terms of the amount of time available?
Well, during the July proceedings, it was initially set for 2 days in July. At some point during those proceedings, it became clear they were not going to finish. The judge then asked, how much time? We're going to come back in September, the judge said. How much time do you need? The attorney for DCF said 3 days. The judge immediately said, you've got a day and a half, and adjourned. Did not make any inquiry into why it was that counsel felt that 3 days was needed. Did not make any inquiry as to any possible way of shortening that time period. Simply said, you've got a day and a half, that's it.
Couldn't the trial lawyer present a deposition in lieu of live testimony and ask the judge to read that? Did the trial lawyer have to call the same evidence, the same witness to say the same thing?
There were perhaps better ways in which DCF could have presented testimony.
Then that's a strategery decision that he made.
Whether it's strategic or not, at the end of the case, there was still relevant, non-cumulative evidence to be presented. There's no question about that. And the department had a right to present that. Now, the case law indicates that the judge has the right, certainly, to control proceedings.
A caseworker, the two parents, one of whom had already testified, and the guardian ad litem, who presumably would testify as to best interest, manifest best interest.
Correct. There was, well, one of the parents had partially testified, was cut off in the middle of the testimony, still on direct. The other and more culpable parent had not yet testified. There was the case manager, and there was the guardian ad litem.
But this was a failure to thrive case, wasn't it?
This was a what?
A failure to thrive case.
A failure to thrive?
Yeah.
Thrive.
Thrive.
TH.
Well, yeah, it was based on the feeding of the children. They were being malnourished and,
Right.
And so on.
So you have a pediatrician, maybe the CPI nurse, nurse practitioner, maybe one other nutrition related, somebody to put on what the standard deviation is and what the standard chart would have been for the child, and did the child fit within 2 standard deviations of the norm?
Your Honor, there's a lot of different ways the case could have been proceeded, but the bottom line, it still comes back to, if there is evidence remaining that is relevant and non-cumulative, there is a right to present it. Now, this judge could have controlled the court differently. This judge could have taken each individual witness and limited testimony when he felt that it was irrelevant or when he felt that it was cumulative in nature.
Or he could have allowed the state latitude to prove their case within the time available.
Well, that
Well,
comes down to the question of whether it was unreasonable to
What is the
establish.
trial lawyer's responsibility to present the case within the amount of time available?
Trial lawyer certainly has a responsibility to make every effort to do so. This lawyer was not able to get that done. This
Okay.
lawyer presented, and it appears from the pace that this case was going, that her original estimate of 3 days was probably a fairly accurate estimate.
Her original estimate of 3 days, and she actually had 4.
No, it was 3 days
and a
from.
half.
It was 3 days from the break point in July. In other words, she said, "I need 3 days in September." That was the point where the judge asked. The judge said, "We're not going to continue here in July. We're going to go till September. How much time do you need at that point?" And the answer was 3 days. The judge immediately said, "You've got a day and a half."
Right.
So right off the bat, DCF is.
And an additional half day for the other side.
Well, it wasn't clear. The judge asked the other side how much time they needed. They responded a
About
much
90
lesser
minutes.
period of time. I believe it was something like 90 minutes.
Right.
One of them said, "I'm going to need a little leeway there." And the judge said, "You're going to have it." Said to the parent's attorney,
Yeah.
"You're going to have the leeway." No leeway for DCF, however. Just leeway for the parents. So that was the situation going in. Now, there's not a lot of law in Florida that applies to this. But I suggest to you that the case that is most applicable is Your Honor's decision in Antoniak versus Antoniak. And that was a situation where after 3 days of trial, the judge cut off testimony, said you may submit written submissions if you'd like. And the wife, the husband, I guess, had brought the suit. The wife then made a written submission and asked for opportunity to present testimony. And it was denied. And this court reversed, saying that even though the testimony was of marginal value, at least some of it was not cumulative, and therefore this was not a fair hearing, that the wife had the right to present that testimony.
That was the wife who was the appellant, right?
That was the wife who was the appellant, yes.
But it was the husband who had a chance to put on all his evidence.
Husband put on all his evidence. When the wife wanted to put on evidence, then it was, no, the time's up.
If we were here with the parents as the appellant, then Antoniak would directly apply. Because it was the party not allowed to put on their evidence who was the appellant.
Well, but I think the more important part is it was the party that lost the motion below.
Well,
The mother lost the motion and so took the appeal. The party that was aggrieved is the party that loses.
I guess, Mr. Bustow, I'm interested in the tension between the right of the trial judge to control his or her docket and the right of the parties to have their case fully presented. I mean, shouldn't we, as a matter of good policy, allow trial judges the leeway to control their docket? Otherwise, things become so backed up that other litigants don't have their opportunities. And I guess I don't know what the rule is that balances those two competing interests.
Well, I'm not sure that any Florida case has established a rule, and I think the points you make are absolutely correct, that there is a balancing process. There certainly is a legitimate interest in running one's court and maintaining a certain pace.
It's fairness to the entire docket. You know.
Yes, I don't dispute that at all. And to get back to your question about what is the standard to apply, I don't think there is a Florida case that sets that forth. As I said, I think Antoniak is the closest. And that's why a lot of my brief deals with out-of-jurisdiction cases. And I would refer, Your Honor, specifically to the Goodwin versus Goodwin case, the Louisiana case, which I think really is probably the best case I have seen throughout the country in terms of setting forth what should be considered in making that balance that Your Honor is talking about. And Goodwin lays forth several factors. The most important one, the first one that Goodwin focuses on, is that you cannot exclude relevant non-cumulative testimony. That the way to deal with that is deal with the witnesses that came first, control them, and so on. If there's still relevant non-cumulative testimony to be presented, then it has to be presented. You have to accommodate that testimony. So that's number one. Number two, reasonable, not arbitrary time limits. What happened here? How much time do you need? 3 days. You got a day and a half.
Well,
no inquiry.
What's wrong with that?
What's wrong with that is that there may have in fact been legitimately 3 days worth of testimony.
Well, what's the difference between that and a teenager who says, a parent says, how much you want in an allowance a week? The kid says $100. The parent says you get $20.
Well, I think there's a big difference. The kid doesn't have a right to any particular amount of money. A party has a right to present relevant non-cumulative testimony. So I think
no, he has an obligation to present it, to prove their case within the time period allotted, right?
Assuming that it is
initially agreed on 2 days.
Well, no, I don't think they initially agreed on 2 days. I think it was set for 2 days.
Initially announced for 2 days.
Well, it initially came up, the court set aside 2 days. We don't know the circumstances under which 2 days was initially set. Clearly, the 2 days was insufficient. Okay. But let me go through a few of them. And to get back to your question, why was that arbitrary? It was arbitrary because the court simply said, day and a half, made no inquiry. Why do you need 3 days, ma'am? Is there a way we can do this differently? Is it possible that you can stipulate to this or that? What is the testimony that you're offering? Is that repetitive of this? No inquiry whatsoever. It was just, you've got a day and a half.
And what is the obligation of the trial lawyer, assuming the judge is required to make those inquiries for the trial lawyer? Does the trial lawyer have an obligation to avoid reversible error by advising the judge of this is what we need to do and this is how we need to do it?
Well, I think that the attorney certainly has an obligation to attempt to fit within whatever time frame may be set, but sometimes it can't be done.
Doesn't the trial lawyer have an obligation of candor to the court on the amount of time
absolutely
that is actually needed to present the case?
Absolutely. And I think if you look at the pace of this case, it appears that the attorney's estimate was in fact a reasonable estimate. It appears that it was proceeding at approximately a 3-day rate. So I think she did. I think she did do that. Let me move on to a few of the other factors in Goodwin, though. It says that it's important to impose a time limit on all parties. That wasn't done here. Not only wasn't it done, it was, DCF, you got a day and a half. Parents, you'll have the leeway you're asking for. Okay? So that was another of the factors.
DCF had a day and a half additional to the 2 days that was initially scheduled, half a day of which was in motions that could have been taken up in pretrial motion practice before getting there.
Theoretically, it could have been, but at that point, nobody knew the judge was going to impose a time limit on the case.
But they knew ahead of time that they had 2 days set aside. Isn't that a time limit?
No. It's an indication that this is all we're going to hear right now. They were not told, at the end of 2 days, you're going to rest. And that is evident from the fact that the judge did move it to September. I think everybody was under the impression that if it was not completed in 2 days, that it would be completed at some point in the future.
It must be a new procedure I'm not aware of.
I'm sorry?
It must be a new way of trying cases I'm not aware of.
Well, That's kind of one of my pet peeves with these cases throughout the state. That's what judges do. I don't know why they don't do a Monday calendar and just try a case to the end, but that seems to be the common way of doing things. The other factors...
Because we have a limited amount of time.
Well,
I mean, part of your argument was...
you have it in criminal,
part of your argument was a claim that the judge took a 2-hour break. Okay?
Right.
Does the record show the judge may have had to review some domestic violence petitions during that break? The judge may have had to do a shelter petition or two at the request of the department during that break?
He may well have. But you know what, Judge? The bottom line is nobody said it was going to be an easy job. That's what he gets underpaid for. And if he's got to stay till 7 o'clock to do his job, that's what he's got to do.
And the trial lawyer has a job to do within the resources available too.
Yes. Agreed.
Okay.
Agreed.
Mr. Musto, you got about 4.5 minutes. I don't.
Okay. I won't go through all of the factors set forth in Goodwin, but I do want to talk about one in particular, and that is how important it is when you set a time limit to make a distinction of the time and equitably charge the time against all the parties. And if you look at the rough calculation I did here, granted it's not scientific, but a little over 40% of that day and a half was taken up with cross-examination, argument, things that were outside of DCF's control. And the case law talks about the need to allocate time. And if DCF is given a day and a half, it should be a day and a half for the presentation that DCF presents. I'd also point out one factor not noted in Goodwin, but that I would particularly point out, is that the nature of the case, I think, has to come into play. This is not a situation where it's A suing B over money. And really the only interests, other than just a general interest in resolving matters appropriately, is the interest of A and B. This comes back to what I started my argument with. It's about the best interests of the child. And as important as it is to hear all relevant non-cumulative evidence, it's even more important here because it can result in a miscarriage of justice that will impact on the child's life. And therefore, under the facts of this case, under this type of case, this conclusion is particularly compelled. Thank you, Your Honor.
Thank you. You have a little more than 3 minutes left in your time. And we'll hear now from the appellee.
Good morning, Your Honors. May it please the Court. Sarah Haller on behalf of the appellee, Y.M. I'd like to start by picking up on Mr. Musto's last comment involving the nature of this case. The nature of this case was, as the Court's aware, a termination of parental rights case, which involves not only the best interests of the child, but also the constitutional rights of the parents. As the Court has noted, this was a case that was filed by the Department of Children and Families under the provision of Chapter 39, which allows the Department to proceed directly to a termination of parental rights, which is an extraordinary remedy and outside of the normal procedure, which requires that the parents be given a case plan and opportunity to cure the issues that brought the children into care. In that sense, I think that these interests do need to be balanced, and I think that what the Court has already noted in this case in regard to counsel for the Department declaring at pretrial that she needed 2 days worth of time to try this case should be considered. The reason...
Is there anything in the record that suggests that the DCF's attorney asked for 2 days of trial prior to the beginning of trial?
There's not, Your Honor. There's no record of that other than, of course, the fact that it was, in fact, set for a 2-day trial period after a pretrial conference. What I think is important is that in these cases, clearly if the Department of Children and Families, or for that matter any other petitioner or plaintiff, is in the midst of putting on their case and has put on quite a number of witnesses and gets to that point in the trial where they feel like maybe they're not getting what they need out of their witnesses, then is the Court to allow them an infinite amount of time to continue to parade witnesses through after the Court is noting that those witnesses seem to be becoming cumulative in order to allow the Department to continue to try to prove their case. And in this case, I would say that this Court did not set an arbitrary time limit. The court was quite clear, both at pretrial conference, which again we don't have a record of, but giving the department their requested 2 days. And then the court needs to note that the decision about the additional day and a half in September was rendered and was made in July. So the department then had months to better prepare its case and to say, I've got a day and a half. Here's what I need to do with my day and a half. Here are the witnesses that I need to put on.
Was it incumbent on the trial judge at that point to make inquiry of the DCF attorney when the lawyer says, I need 3 more days? Should the trial judge have said, well, why do you need 3 days? And tell me what witnesses you intend to call and what they intend to say so that we can figure it out. I mean, I'm torn here because on the one hand, it is an important case, both from the parents' perspective and the children. And, I'm inclined like in a first-degree murder case or in a case of this nature to maybe give the parties a bit more leeway than I might as a trial judge in a more routine matter, and the trial judges need to manage his or her docket. But don't you think it would have been incumbent at the very least for the trial judge to say, well, why do you need 3 days? Instead of it seemed to me from looking at the record that the judge just sort of arbitrarily said, well, you get a day and a half and do your best.
Your Honor, it's a good point, and what I believe is it takes me to another point, which frankly was the focus of my answer brief, which is I believe, in fact, that trial counsel had an obligation to say, yes, Judge, you've told me that this evidence has been cumulative, but here are the witnesses that I want to bring, and here's what they have to say. Mr. Musto noted that there's no question that there was further relevant non-cumulative evidence to be presented in this case. Well, we don't know that, and we'll never know because there was no proffer of the evidence. In fact, the cases that Mr. Musto has cited, both the Antoniak case and the Sullivan case, which is noted in his brief as the only other really Florida case that he cited, both indicate that the failure to proffer that evidence is fatal to bringing an appeal on that case. And the reason is because, again, we can't assume that the evidence that was to be offered from the department case manager and from the guardian ad litem was going to be non-cumulative relevant evidence. I believe, in response to your question, sir, that it was the department counsel's obligation to say, here's what I've got, and to bring to the court's attention the reason that she actually needed that time, in addition, of course, to her obligation to being able to get that evidence before the court in time.
Do you have any quarrel with the factors that are set forth in the Louisiana case, the Goodwin or Godwin case? Do you think that's a reasonable approach that Florida should consider adopting? And if so, isn't one of the factors in there that the judge really ought to be a bit more proactive and in determining what a reasonable amount of time is and why the party's request is or isn't reasonable?
Yes, sir. And to be honest, I think that any time that we're left with, as the court's aware, the Florida Statute 9612 allows the trial court to manage the trial docket and to control the time in what's called a reasonable manner. The case law says that he shouldn't be arbitrary or unreasonable, but Goodwin does set out some more specific factors that probably give us some better guidelines. But what's important to note is that the primary factor in Goodwin is that the court should not exclude relevant non-cumulative evidence. And again, we don't know that there was any exclusion of what was non-cumulative or relevant evidence in this case, because we don't know what that evidence would have been, because there was no proffer of such evidence. We can all presume, and I suppose if we were to presume, we can deduce that neither the case manager nor the guardian ad litem were involved in this case before it came into the court system. So certainly they were not fact witnesses who could have testified about any of the circumstances that led up to this family being involved in the court system. I think that it's the obligation of trial counsel to bring to the court's attention what that important evidence is and to show the court that it is relevant and non-cumulative evidence.
I read the good portion of the transcript of the case, and I didn't get the impression from the trial judge that he would have been very receptive to further discussion of the matter. I mean, what I see here, I mean, my sense reading between the lines is that I saw a very inefficient presentation by DCF and a very frustrated judge who didn't jump in early enough and say, you know, you guys are really wasting a lot of time here and we need to get to the point, and just sort of kind of got frustrated at the end and said, game's over.
Well, and yes, sir, there may have been some frustration on the part of the judge, and I think that something that should be noted is, for instance, the pretrial motion, which occurred prior to the start of trial, in which the department alleges took a half a day of its trial time, was actually testimony from a nutritionist, which was evidence that the department then sought to put on through a registered nurse practitioner, which was the same evidence that was put on by the registered dietitian. So in other words, right there is a place that the department could have saved itself an hour's worth of testimony. The court inquired whether the department could have introduced depositions in lieu of live testimony. There were 3 separate psychologists who testified, and their reports were already moved into evidence. So the department then spent an hour at least on each psychologist, each expert, going through the details of their report when the report itself had already been moved into evidence. So I think that there was some frustration. I think that that was apparent after the conclusion of the second day of trial in July. However, again, after the conclusion of the trial the second day in July, the court said, I'm giving you another day and a half. So in fact, the department did have fair warning and did certainly have time to prepare their case and say, what's the best I can do with my day and a half? In addition, I think if the department had wanted to pursue the issue, that perhaps even prior to picking up the trial again in September, the department could have come in, asked for additional time, said, we have gone through these witnesses, we've laid out what we believe is the relevant evidence for the court. We can't get it done in a day and a half. Here's how we can get it done. Here are the witnesses that we intend to offer, and here's what their testimony would be.
Counsel, looking at some of the commentary of the trial judge, who, by the way, did say, I'm not the one who came to pretrial and made representations. You did, counsel. You were told at the pretrial, based upon your representations, how long this trial should take you. The court attempted to assist you during the course of the trial to move your case along, and so forth and so on. But I'm most interested in his comment and in his determination that he found the children to be dependent. What do you make of that?
Well,
I guess even more particularly, I'm looking at this as kind of a harmless error thing. If the children were determined to be dependent and not returned to the parents, and if the case plan is, if the parents are unable to complete their case plan, doesn't DCF get to go back again and seek to terminate?
yes, sir, absolutely. And so the department will...
So where's the harm here if the children are declared dependent and they're not in the control of those parents anyway?
Yes, sir, I agree. And maybe even further to that fact, I think that that the judge was very clear by the evidence that was put on. The facts were what they were. He didn't need to hear any more of it. He knew what the facts were. The piling on, so to speak, of the evidence and the psychologists were cumulative, when certainly the facts had been proven, and the parents are not here today to dispute the finding of dependency. So these children are not returning to the home unless and until the parents complete their case plan. The department will have another shot at this if, in fact, the department or the parents do not complete their case plan.
And he found specifically that there was no testimony as to the endangerment or of the life of the child from any witness other than on a speculative basis. So clearly he wasn't impressed with an endangerment issue here.
Yes, sir, and I think that is likely what led to the court's frustration, because again, the facts were what the facts were, and to presume that the dependency case manager or the guardian ad litem, who might be able to offer an opinion or some degree of testimony about how things procedurally had been laid out, again, they weren't fact witnesses. The court heard all of the fact witnesses in this case that had to do with what had happened to these children, and made a finding that the children were dependent, which is certainly a much lower standard than the standard required to terminate parental rights on a petition filed under this section of Chapter 39. So in addition, Your Honor, I would like to point out that I believe that, again, it was the obligation of the court to manage its docket. Certainly, it's not a situation, as the court's well aware, dependency courts are overloaded in this state with cases. There is not sufficient trial time. The court has to be mindful of other cases that are waiting on the court's docket for trial time, and cannot allow the department nor any other party to come in and just try a case and present cumulative evidence in the hope that they're going to throw something out there that's going to change the judge's mind about what the judge has already heard. So I think that the trial judge has an obligation, certainly to the case that's before him, but also as the manager of the trial docket and the court responsible for hearing all of the dependency cases assigned to that docket, to keep things moving in a fashion that allows all of these cases to be tried in a timely manner. Thank you, Your Honor.
Thank you, counsel. All right, Mr. Musto. Yeah, let me ask you, what happens if we agree with you 100% and send the case back for, what do we send it back for, a retrial?
I would ask that you reverse the portion of the order that denied the petition for termination of parental rights, send it back for a determination, continued trial, or a new trial on that basis.
If there's a failure of the case plan under the current scenario, don't you get a new trial anyway?
Well, certainly if there is a current situation, there could be a new trial in that set of circumstances.
And if they complete the case plan, well, terrific for everybody.
Well, if he complies with the case plan, I'm not sure what the situation is in that regard. But that's going to be inherently true any time a situation like this comes up where it goes back along those lines. The bottom line is whether the termination was the appropriate matter. And I think on that regard, it's important to point out, we've talked about a lot of different possibilities. The basis for the court's ruling in the record on page 414 in the order was that DCF failed to show manifest best interests. And that's exactly what the guardian ad litem was there to testify to. So the fact that some of the witnesses did not...
Was that proffered?
Well, it was proffered that... Well,
was it proffered?
Let me put it like this. There's nothing in this transcript that shows a proffer. However, in the court's order, the court says... Who
is responsible to make the proffer?
DCF is responsible to make the proffer.
Okay.
I suggest to you that a proffer was made, however, because the court in its order says DCF indicated that the following witnesses would have been presented had they been allowed to continue. So clearly this was transmitted to the court. Now, it wasn't done while the court reporter was there or while the tape was on, But the purpose of a proffer is to make the judge aware of what the issue is. From the order, it's clear that this judge was aware of it. It's clear that we are all aware of it. There's no surprises here. So the purposes of a proffer were clearly met, and to say that just because it didn't happen to get in the transcript should preclude the argument of this issue would be form over substance, I would suggest. I would also like to turn just briefly in my closing seconds here to the comments that Judge Orfinger made about this may be a situation where DCF was dragging its feet and the judge didn't jump in. And I think that's a very accurate assessment of the situation. But let's assume that DCF just did a terrible job and was presenting all sorts of cumulative evidence. It is the judge's obligation to jump in. And the Clark case that I cite in my brief out of Massachusetts talks about that. When a court imposes a time limit, the court has an obligation to ensure that trial proceeds without repetitious and irrelevant examination. The case is cited in footnote 10 of my brief, gives some Florida law that talks about the court's authority to do that. And what it comes down to is it's particularly important here because assume DCF was terrible, you don't punish the child. If it happens with a lawsuit between A and B over money, fine, punish A, but don't punish the child, and that's what this case is about.
Thank you, counsel. Your time has expired. And I suppose we are in recess at this point. Counsel, both of you did a great job. Appreciate your arguments.
Thank you, Your Honor.